Good morning again, everybody. So I'm going to bring you a little bit closer to home, hopefully, and look at, just provide you with a very brief overview of HIV criminalisation laws in Africa. So I wanted to start off by stealing a quote from one of my biggest heroes of all time, Judge Edwin Cameron, who will be here joining us a bit later. Don't tell him I said that. But his response to criminalisation was that it makes it more difficult for those at risk of HIV to access testing and prevention. There's simply no evidence that it works. It undermines the remarkable scientific advances and proven public health strategies that open the path to vanquishing AIDS by 2030. Despite this, we see in Southern, East and West Africa an epidemic of laws that have proliferated. Several countries in Africa have either adopted or in the process of considering the adoption of HIV-specific laws that specifically criminalize HIV transmission, exposure or non-disclosure. And I suppose sometimes I understand where this comes from. There were good intentions behind this, I think, but very bad policy. As Edwin pointed out, these laws are very often very overbroad in terms of their provisions, and really do hinder prevention efforts and exacerbates existing stigma. This is another one of those maps that you can never really see. I don't even know why I keep it in the presentation because it's difficult to see, but you can the differing shades of red. The darker red is where we have HIV-specific criminal laws, and the lighter red are, with prosecutions, and the lighter red is HIV-specific criminal laws where there have been no reported prosecutions. The point is that there's quite a lot of red of differing shades across the map, which is not a good thing. When I sit now, sometimes I understand the sort of drive for these criminalisation provisions is, I think the first time at ARASA we ever talked about this in a regional meeting was in the early 2004, somewhere around there. And at that point, the calls for criminalisation were interestingly coming from women's organisations. It was women's organisations where women were terrified and tired of being infected within relationships where they had no control over the enforcement of safer sex decisions, or of leaving a relationship in a situation where there was abuse or exposure to HIV and no way of getting out of it. And so at the beginning of this debate, and certainly in this region, a lot of the support for the criminalisation provisions came from women's organisations, which I understand. But as we unpacked that, it was actually quite an amazing meeting, that one in 2004, because it was one of those meetings where there were suddenly like aha moments going around the room, where when we started unpacking what the impact of HIV criminalisation was on women, it became very clear very fast that this was really not a very good idea. Women are the first to know their status very often within relationships, but attending antenatal care, often not in a position to disclose their status to their partner because of a very real fear of violence or being ejected from the home, being economically dependent on their partner and not being able to leave, often blamed for bringing HIV into the home. And then at the end of the day, when the partner finds out that he is HIV positive, whether or not he knew before is another issue, obviously. It's the woman who gets blamed and the woman who gets prosecuted. And we see this happening over and over again. And when we unpacked all of this, people were like, whoa, no, that's not such a great idea. So while there were probably good intentions behind some of this, obviously we've realized, as we've unpacked it over the years, that this is really not helpful. HIV criminalisation is not helpful in our response to HIV. Edwin's already looked at this. Obviously, there have been scientific and medical developments over the last 5-10 years, where, in terms of harm of HIV transmission, HIV infection now is much more of a chronic, manageable health condition than it was in the past. We've seen the effectiveness of treatment as prevention and the reduction in risk of HIV transmission, where people are on treatment and adherent. We've seen better understanding of both the advantages and the disadvantages and limitations of phylogenetic evidence, which we're going to be looking at tomorrow, I think. And we've seen very clearly the negative public health impact of HIV criminalisation. So in the region, just quickly, there have been some good steps forward in Liberia, and I believe we have a colleague from Liberia at the back who can probably elaborate more on this at a later point in the proceedings. But in Liberia, the HIV Act, although it does specifically provide for HIV criminalisation, it does very specifically restrict the instances of cases in which people can be prosecuted for to willful transmission, and it specifically provides that no person commits an offence where the act poses, firstly, no significant risk of HIV infection, or where the person was unaware of their own infection, or where they lacked understanding of how HIV is transmitted, where they practice safer sex, where they disclosed their HIV status to the other person, or where the other person was aware of their HIV status through other ways. So that was Liberia is an example of an HIV creation of an HIV-specific offence, but was very careful to limit the application of that offence, which deals with a lot of the criticisms of the overbroadness of HIV criminal provisions in other laws. In Kenya, and I see Kenya is in the majority, I think, in this room. I don't know what they do, but they seem to come out in numbers. In Kenya, and many of you in the room were responsible for this, was the striking down of Section 24 of the HIV and AIDS Act as being unconstitutional because it was vague and overbroad. We've seen at the SADC parliamentary forum level a real change in attitude on the part of parliamentarians in the SADC member states. We saw in 2015 a motion which we'd never have seen adopted previously, where they basically called on member states to consider rescinding and reviewing punitive laws specific to the prosecution of HIV transmission, exposure, and non-disclosure. And I have to tell you, that journey with parliamentarians took a very, very long time, many years of persevering. And I think is a good example of how the results from this kind of work, and I'm speaking to some people specifically in the room, that the results of this kind of work do not happen overnight. It takes a long time for this impact to happen. In Malawi, we've seen the case of EL versus the Republic. The lawyers responsible for the litigation of this, Wesley at the back, another of my heroes, where, and again, this was a case not only of lawyers being able to litigate this kind of matter competently, but also having a judge who had also gone through similar trainings organized under the regional program on removing legal barriers for Africa, where we've also seen a number of judges really getting it now, suddenly understanding that actually there is something we can do from this we can do about this as judges in terms of our, and to some extent judicial activism, which has been lacking in the region over the years. So these are very, very concrete results of this program that we've been talking about, the Removing Legal Barriers program. Wesley will talk more about the Malawi case, but basically this was a woman living with HIV who was on antiretroviral therapy, was convicted of a crime under the penal code for breastfeeding another person's child, which she did accidentally and it wasn't intended. Basically she was convicted, even though the child didn't contract HIV, and the evidence indicated that the breastfeeding was accidental and unintended. She was sentenced to, 9 months with hard labor? 17 months with hard labor. Taken on appeal to the High Court. Judge, who I only ever know as Judge Z, Judge Ntaba, yeah, Judge Z, basically set the conviction aside and said very specifically the criminal law shouldn't be applied to cases where there's no significant risk of transmission, where the person didn't know that they were positive, didn't understand how HIV is transmitted, and didn't disclose their HIV positive status because of fear of violence, and was very clear about the need to limit the use of criminal law in the response to HIV. My last slide is Malawi again. Malawi has been featuring quite well in the news recently in terms of advances. Again, people in the room, Sarai, Wesley, other people, for years and years, the HIV draft, the draft HIV and AIDS prevention bill wallowed in and out of Parliament in Malawi for how many years? Long time, 10 years or something, yeah. And a lot of great advocacy on the ground from Malawian lawyers, Malawian activists, women activists. As a result of all of that, it was in December last year, they managed to persuade parliamentarians that all of the problematic sections, the one that related to exposure, to intentional transmission, and reckless or negligent transmission, all of them were removed. They persuaded parliamentarians that this was not useful in the response to HIV, and is a very good show of how lawyers and community grassroots activists working together on the ground can really have the power to make change. So, thank you very much. I hope that gave you a bit of an overview of what's going on in Africa. You're going to hear a lot more in the next couple of days. Thank you very much. Thanks.